it means to define a null hypothesis and to test the null hypothesis against the data. But of course, in that discussion, I didn't talk about, well, which null hypothesis do you pick, right? Which null hypothesis do you choose to test? Now, the example that I gave, I said, well, look, our null hypothesis is that the average law firm size is 11. That really doesn't make any sense. Why do we care? I mean, nobody cares about whether or not the average law firm size is 11. So that's not a good hypothesis to test. That's just a hypothesis that's made for an easy example. So what is a good hypothesis to test? Well, if what you're doing is defining a null hypothesis and seeing whether you can reject the null hypothesis in the data, then what makes a good null hypothesis is a belief that is interesting to reject. Okay? Which means if there's something that you think is accepted to be true, but you also suspect may not be true, or if there's something that one group of scholars believes is true, and there's something else that another group of scholars believes is true, right? Then one of those two beliefs can be the null hypothesis, and you can try to reject it. Okay? So you can. The idea is you want to choose a null hypothesis that, if you reject it, will allow you to reach some conclusion that's relevant to the study of law, right? The idea here is if you have some research question, right, you define some question, some relevant question about the law or policy that you want to learn about, you want to define a null hypothesis such that if you reject the null hypothesis, you are able to reach some conclusion about, oh, now I thought we should have supported this law. Actually, no. Now that we've rejected this null hypothesis, I think we should not support it. Or I used to think that Professor so-and-so's theory was right, but now that I've rejected the null hypothesis, I am now skeptical of Professor so-and-so's theory. Something like that. That's the idea. Okay. Now, so one of the things that I do want to mention is, again, all a regression will do is talk about the correlations, the statistical relationships in the data. It won't tell you whether or not you've asked a good question and therefore have a good answer. So just because you run a regression and your p-value is less than 0.05, that's statistically significant. But it might not be legally significant, right? It might not be meaningful or interesting. It might just be, wow, that's different from 0, but nobody cares that something is different from 0, right? So the question is, do we care that something is different from 0? That's what makes a null hypothesis a useful hypothesis for statistical testing. Now, to be clear, not every, we were just having this discussion a moment ago, not every hypothesis that's generated by a research project necessarily requires statistical testing, right? But to the extent that you're trying to show the existence of a quantifiable relationship between two variables, and you want to know whether that relationship is big or small, you want to know whether it's negative or positive, you want to know whether it's 0, there's no relationship at all, or there is some relationship that's different from 0. Well, those kinds of questions are the kinds of questions that are good for statistical hypothesis. Okay. And so this, I think, maybe is the slide that relates best to the first part of the discussion today. So, most of us in the room are not ourselves empiricists, or maybe not yet anyway. But everyone here is a lawyer, right? Everyone here has ideas about how the law works. We have theories about how the law works. We read cases and doctrine that offers theories, models of human behavior that may or may not be right, but they may or may not be the law. And so the question is, when is a theory about the law the kind of theory that's good for this kind of hypothesis testing, the kind of hypothesis testing I'm talking about? Well, it has to generate predictions about what will happen, right? Some prediction about what relationships in the data will look like if we look at the data. And if that theory generates a prediction, what we want to do then is define a null hypothesis that can be rejected. And so if you have two theories, you know, remember I gave the example. One theory was criminal behavior is caused by unchangeable psychological problems. Another theory is criminal behavior is influenced by incentives created by punishment from the law. Those are two theories, and they generate conflicting empirical predictions. One theory generates the prediction that if you lengthen sentences or increase the likelihood of conviction, there will be no change in the number of crimes committed. You might put more people in jail, but the rate of crimes being committed will not change. The other theory says, if you increase enforcement of the law, then people will be deterred. They will be discouraged. They will be incentivized not to break the law. So you could imagine there, if you're Gary Becker and you're trying to empirically test this theory, your null hypothesis is that when criminal enforcement rises, there's no change. Right? There's no change in crimes. The alternate hypothesis is that when enforcement rises, there is a decrease. There's a decrease in crimes, right? So that would be taking theories that are meaningful and important to the law and translating those theories into quantifiable hypotheses about relationships between variables in the data that can then be tested. So then if you run a regression on the relationship between the amount of criminal enforcement, so maybe it's the number of prosecutors, the number of investigators, maybe it's the number of police, maybe it's the amount of the budget for law enforcement, whatever your measure of law enforcement is. You run a regression on that measure and then the level of crime, the number of crimes. And you can ask yourself, is the relationship statistically significantly different from zero? If it is, then you have rejected the theory that generated the null hypothesis, right? The theory that crime is purely a mental defect and doesn't respond to incentives. You haven't proven the alternate hypothesis. You simply supported it, right? As we've said, you can never prove any theory with just one study, right? Empirical work doesn't work that way. It's the accumulation of many pieces of evidence over time to establish a theory. But you've at least moved the needle, so to speak. You've caused us to be more willing to reject the old theory and more willing to accept the new theory. Okay, yeah.
See, suppose my hypothesis is that the review of literature is the starting point of research, and your hypothesis is, no, it is not the review of literature, but it is the statement of problems, the originating point of any research. So how are you going to analyze the number one null hypothesis and alternate hypothesis for the purpose of these two statements?
Okay, okay. So that's an example of a pair of hypotheses that are clearly articulated and clearly in conflict, right? But the question is not an empirical one, right? The question is not about quantities. It's a normative question. What is the right way to do research, right? It's a normative question. There's nothing an empiricist, right, can do, right, to answer that question. But, you know, if you ask my opinion on that question, I think the answer is it depends. I mean, so certainly I know that there are plenty of researchers whose approach to generating questions, right, is to read the literature and to ask, here's the ideas that exist in the literature, and where are the gaps? Where are there questions that haven't been answered, or where are there questions that haven't been asked? So that's definitely an approach some people take. You know, other people just ask, you know, what's interesting to me? I'm going to explore something that's interesting to me, and I'm going to ask a question that I think is important, and I'm going to ask myself, do I have a way of getting at this question that's important to me? And then I'm going to go back and check to see if somebody else has already answered it. You know, I think there are pluses and minuses to both approaches. But anyway, that's a conversation for another day. Okay. So any other questions about this? Okay. So let me say a little bit about these papers, and I would welcome any thoughts you have about the paper. So, the paper on witnesses, right? The professor shared with us earlier, is an example of a particular kind of way of generating data, a particular way of creating a sample of data. So this was a survey methodology, right? It was a survey where investigators went out and identified people to interview and collected information based on the interview. Now, it was a stratified survey. Somebody mentioned stratified sampling earlier. So what does that mean? Well, ideally, you want to get the whole country, right? You want the whole country, data on the whole country. But, think about how expensive it would be to go to every single court in the country and interview 1 or 2 people so that you have 800 people from the entire country. That would be so expensive. And the reality is, empirical research, it's often constrained as much by practical considerations as it is by theoretical statistical considerations. You may not have the budget, you may not have the time, the people power, the money to collect a gigantic sample. Maybe you can only collect a smaller sample. So what do you do if you're limited in terms of your budget? Well, one of the things you can do is to stratify. Ideally, you want to randomly select witnesses from all over India, from all different case types. Too expensive. So what do? You stratify. Say, rather than randomly selecting witnesses from all over India, randomly select states from all over India, and then within the few states that you randomly select, you then randomly select cities or courts within those states. And that way you're randomly selecting at each stage, but you only end up going to 8 courthouses, right? Rather than 800 courthouses. And you're interviewing 100 witnesses in each of the courthouses, instead of 1 witness in each of 800 courthouses, right? So the idea is you're still getting a random sample, but by stratifying, by randomizing at different levels, you're able to reduce the cost of collecting the information. Now, this was an interview-based survey. We talked a little bit about surveys and interviews last time. Now, you might compare that to the disinclined to dissent, right? Which some of you may have had a chance to read. This is an example of a much more common type of data collection in empirical legal studies, which is collecting court cases, right? You collect the court cases, and then you convert the information in the court cases into quantifiable data by coding them. Right? You often create a spreadsheet. Maybe you have an Excel spreadsheet where you have the variables of interest, and you read the case and you look for, what's the date of the case? Okay, this is the date. Okay, read through, which judges? Okay, these are the judges. Okay, who won? Plaintiff or defendant? Right? And you go through and you create the data that way by hand coding the data. So that's a very common data collection technique, and I think the author does a really nice job of recognizing that because she did the hand coding herself, there's an element of subjectivity, right? And we talked about that last time. But ideally, you can reduce subjectivity by focusing on variables that involve less judgment in terms of how to code them, right? So the date of the case, who the judges were, who won, things like that. There's not a lot of subjectivity to that. On the other hand, was the case well reasoned? Okay, well that's going to be a highly subjective judgment. You might be less confident in your coding of that kind of issue. One of the things I also really liked about this paper, although I'll also, I'm not going to praise papers. I'm from the University of Chicago, and one of the things the University of Chicago is famous for is brutally criticizing all academic work, including our own. We're completely equal opportunity critics, and I think that's an important part of this kind of scientific research is professional norms in many contexts dictate that we look at each other's work with a lot of a gentle, respectful tone. But I think when you're looking at empirical work, you should always be respectful. But it's important to be critical. I think it's very important to be critical because no work is perfect. Even excellent work can be criticized. But if you don't criticize work, it won't become excellent. It won't become excellent unless you're open to criticism and unless people are willing to criticize. So I will criticize this work, even though I do think it's a quite excellent example of work that's being done on the Indian courts. So what does it do? So as she goes through, she begins by motivating a question. She says, okay, here's an interesting question. Then she states a hypothesis. Then she describes how she's going to test the hypothesis in the data. And then she tells you what the results are. And she does this over and over and over again in the paper. And that's a really nice way to structure a paper. So let me just give you an example of this. So on page 10, section 4.1, so the impact of the bench size on the tendency to dissent. Right. So it talks about how there's how you might think just as a matter of intuition, and then in fact the literature suggests this as well, that we might think that the bigger the panel, the more likely we are to see dissent. Okay, so she describes that this past research has suggested that. So then she draws out of this research a hypothesis, right, that dissent rate grows with the size of the bench. And then she says, well, what does the data tell us? Well, let's look at the data. And she presents the table that shows here's the dissent rate by the size of the bench. And it actually is a positive relationship. Okay? And so that's an example of identifying a hypothesis from the literature and then testing it in your own data. Now you'll notice, of course, this is just a correlation. The suggestion, of course, is that it's the size of the bench has a causal effect, right, on the likelihood of dissent. And there's a reason to think that makes sense. It's, it seems odd. It might seem odd that the likelihood of dissent causes the bench to be bigger, right? That seems very strange. Although it's not impossible, actually. It's not impossible. So let me explain why. So you might think to yourself, look, a case goes to a two-judge justice bench, and they disagree. Well, what are they going to do? They're going to refer it to a larger bench, right? Which means there's a tendency for cases with disagreement to end up in larger benches, right? So it may actually, as strange as it sounds, be the case that the likelihood of dissent is causing the bench size to be bigger and not the other way around, right? It's not that the bench size is inherently causing the likelihood of dissent. So this is an example of a case where the correlation is very clear from the data, but we have to be more cautious about saying which is causing which. It's probably both is probably the answer, but in any event, that's the idea. So another example, a couple interesting examples here I wanted to mention. So here's so on page 14, for example, it talks about the hypothesis that cases involving important issues are more likely to involve dissent than other cases. And we look at the data and we see that it appears that some of the categories, such as constitutional cases, do seem to have higher dissent rates than, say, service cases. And then the paper goes on to try to explain this result. What's the intuition for the result? Because after all, the pure correlation in the data is never enough for us to conclude that it's a meaningful result, right? We have to have some theory explaining why this correlation is important to us. And then finally, there was one other example I wanted to give as just kind of something to think about here. Page 18. The hypothesis is, does the presence of the Chief Justice on the bench have an effect on the tendency of the remaining judges to dissent? And what's good about this particular example here is, it turns out there's a null result, right? There's not really a clear relationship in the data. And so rather than just not bothering to write it up and just ignoring it, she still includes it, right? She still shows the result that didn't come out the way she expected. And I think that's important to sort of show all of your research so that people understand that, sometimes there are null results as well. Now, if I wanted to criticize this paper, I would say, well, she could have been a lot clearer about articulating the hypothesis, right? So when I write a paper, and you'll see some of my papers, what I often try to do is be really explicit, say, this is my hypothesis. Or even to say, here is hypothesis number 1, bullet point, number 2, So that it's very easy to find the hypotheses in the paper and to go back and check to make sure I've actually tested them. So that's, if I wanted to criticize. The other thing, I guess, if I wanted to criticize is we don't actually see for all of these, we do see for some, which is nice, but we don't actually see statistical testing of whether the trends, do dissents rise with the size of the bench? Well, I'd like to see a statistical test of whether that correlation is statistically significant, right? So that's something that could have been better in the paper, although there is some of that in the paper, which is helpful. Oh, another nice thing actually about the paper, a good example of this is there was something towards the end, what was it? Where she tested something 3 different ways. She tested something 3 different ways. And that's a way of looking at the robustness of a result. So you always worry that you get some result that looks really good, but maybe it was just luck, or maybe there's something funny in the data that you didn't realize, some omitted variable that's causing the result. But if you test the same hypothesis multiple ways and you keep getting the same answer, that's a way of saying, oh, this result is more robust. I'm more confident that this really is a true thing and not just some fluke in the data, right? So that was a nice attempt at robustness testing, although, funnily enough, one of the robustness checks was a null result, so it kind of weakened the result, but I think, that's just good science, acknowledging that it's somewhat robust, but not entirely robust. Any questions about this paper? I want to go quickly because in case...
I'm a little confused about the second analysis you're doing regarding correlation, that it's not being done properly.
Oh.
So what is the criticism you just made? If you can articulate.
Oh, no, so here's the good and the bad, I guess. So the positive thing is the tables very clearly lay out, look, here's the descent rate for 2 judge benches, here's the descent rate for 3, for 4, for 1. So that is great because it's transparent, it's easy to interpret, you can see for yourself, right? You can see it for yourself. You don't have to rely on some fancy regression result. But because it's a pretty good sized sample, but not huge, you might ask yourselves, is this correlation sufficiently strong that we think it's statistically significant? In other words, is it possible that this correlation arose just by chance? And so what you could do, for example, is run a regression where the outcome is percent and the the regressor, the right-hand side variable, x, is the size of the data, right? So you have, I forget how many, like 290 cases or something. So for each of those observations, you have whether or not there was a descent. So it'll be a 1 if there's a descent and a 0 if there's no descent. So that'll be your y's. So it'll be a lot of 1s and 0s. And then your x's will be bench size. Is it 2, 3, 5, 2, 2, 2, whatever. And then you run a regression between those 2 groups of numbers. And the regression will say, well, if the slope of the line is 0.2, then that wouldn't be 0.2 in this data, maybe let's say 0.1. Then that means if the bench size increases from 2 to 3, the increase in the probability of descent is 10%. So it goes from, say, the probability of descent being 1% to being 11%, right? So 10% jump. And then you would see from the regression results whether that increase is statistically significantly different from 0. So that would be a way of saying, is this due to random chance, or is this a strong relationship?
And that is what ultimately we are aiming at, to figure out it should not be a random chance.
Yes, I mean, again, it's the important thing isn't whether or not something, whether or not you run regressions. The important thing is how confident are we that this relationship we care about really exists, and the significance testing is one way of getting it.
Regression leads to prediction, or regression leads to establishing a correlation?
So, okay, good question. So regressions, the regression analysis estimates a correlation, right? So that's the beta. And then when you test the statistical significance of that estimate, what you are doing is asking, is this a good prediction, right? As opposed to random chance, okay? Now, so the beta gives you correlation, the statistical significance testing gives you prediction. Now, how do you get to causation?
That's a different.
That requires interpretation. That's where that's the human element. We have to think about: do I believe these results? What are the reasons why I should believe these results? And that requires, thinking about what is the legal context? What are the incentives of the people? Why might this data have confounding factors, right, such as omitted variables that we talked about yesterday? So maybe I'll say a little bit about the third paper. We actually have one of the co-authors here today, Rahul Hemranjani. So it's always awkward presenting someone else's work when they're in the room, but I thought this was a really neat paper, and so I wanted to include it. So the first paper we saw today was an example of a stratified survey interview methodology, right? The second paper was hand-coded cases, right, which is a very common methodology. Here we have a third methodology for gathering and collecting data, a much more recently developed method, which we kind of call, I guess, web scraping. Is that a fair way to put it? Yeah. And so what you see here is sometimes it's much faster and much less expensive, rather than hand coding or rather than hand collecting data, to get somebody who knows something about computers and get them to basically go to a website that contains information and just pull all the data. And so, last year, 2 years ago, actually, I had a company right here in Delhi, actually, go to the Indian Supreme Court website and collect records of every Supreme Court case, every SLP petition, every admitted SLP petition, every rejected SLP petition, since 1992. So it's something like, I forget how many. It's millions, anyway. Millions of, there's no way anyone could ever hand code whatever it was, 8 million cases or whatever. But if you're just scraping a website, if you get somebody who's a decent, pretty good with software, it's not that big a challenge. So this is an example of this kind of new technique for collecting data. So Rahul, I didn't know if you wanted to say a little bit just about your experience in terms of working on this project and design and stuff.
Sure. I mean, the sort of problem that so this is not a causation paper. This is not a paper which is dealing with relationships. It's essentially dealing with lack of data in a very specific field in the Supreme Court workload. So the problem that we're facing, and every Chief Justice will make a statement as to the pendency of the Supreme Court, including very recently Chief Justice Misha. And the problem that we were facing was that people were describing pendency in terms of absolute case numbers. And this is, people were doing, there are several law commission reports, there are several scholars, Nick Robinson has been mentioned. There have been several people who have been attempting to understand the workload of the Supreme Court using case numbers. Now the problem with that is that the Supreme Courts and its capacity to deal with cases is not dependent on the number of cases. So saying something like, oh, there are 1 million cases pending in the Supreme Court, really doesn't give us too much information. It really doesn't tell us how well the Supreme Court can sort of handle that 1 million cases. Perhaps 1 million cases can be handled in a day. Perhaps they'll take 30 years. The scarce resource in the Supreme Court is the time that people get to hear the case, or the hearing time of the case. And unfortunately, for a long time, there was no data on this. And we were trying to find ways in which we can sort of collect this data. One of the ways was, of course, to actually send a researcher into each courtroom, keep a stopwatch. In fact, a similar thing is done in the US and UK, sort of federally sanctioned studies on courts where there is a stopwatch available with the administration to see the time for each case. But that's not available in the Supreme Court of India, and the Law Commission, in fact, made a comment on this, that there is no time data available. And the interesting idea that we came up with is that the display board of the Supreme Court, which is used essentially by lawyers to see which case is going on in any given time, can be used sort of to proxy the stopwatch. So essentially, whenever there is a change in the case being heard, this display board changes. The item number in the display board changes. So what we did, and this is again we didn't do this personally. There's a company in Delhi which did this for us. Essentially, they marked a timestamp every time the display board changed. And once you have that timestamp, you can compare the two timestamps, one when it changed before, one when it changed from 6 to 7, and then once when it changed from 7 to 8. And we can compare the difference of time between the two, and that is, to the best of our ability, that's the amount of time the court took to hear the case. You know, subtracting some administrative time for the court clerk to change the display.
So, I'm sorry, let me jump in right there. So I think there's a couple of things that come out of this this discussion that are very helpful. So one is the prior research, as Rahul notes, the prior research was not able to generate estimates of how long each case was taking, right? And that's, of course, what we want to know, because we want to ask ourselves, how long would it take the court to resolve the cases that it has pending? And I think, nonetheless, when you look at the earlier research, it's not that it's not helpful at all, right? Knowing how many cases it has and how many cases it's clearing allow you to come up with a rough estimate of how much time it's spending per case. But I think that reflects the fact that many times when there's a question, that we have a research question, a question that is important for the law or important for policy, the measures that we have available to us may not be the ideal measures. So when you think about how to approach an empirical question, you will begin with, as we talked about earlier, we'll begin with what's the question that you want answered, right? And what are the hypotheses that you would like to test in the data? But then there's the practical question of, well, okay, in a perfect world, what would my data look like? If I could imagine, conjure up whatever data would be perfect for answering this question, what would that data look like? And then you have to ask yourself, okay, this isn't that world, this is the real world. What's the closest I can get with real world data to the ideal data? And, it may have been, in the past, the best you could do was to simply look at the number of cases, right? Or maybe send somebody into the courtroom with a stopwatch. But that's very expensive, and there's a trade-off between cost, right? Maybe you don't have the budget to get a lot of cases that way. But, then as better technological options become available, you can be creative and try to think about new ways to answer questions that will more precisely tailor, precisely match the type of data you're collecting with the type of question you're asking, right? And so ideally you want there to be a really good fit between what you're asking and what the data can tell you. If there's not a good fit, you have to ask yourself, well, what's the best proxy, right? What's the closest data for the question I'm asking? And then you have to, of course, assess yourself, for yourself, is this proxy good enough, right? Is this proxy good enough for the question that I want to ask? And honestly, sometimes the answer to that question is going to be no. There are plenty of times, in fact, when I've had an empirical research question, I've had a question I've been dying to answer, or a question that I said, oh, this would be so brilliant if I could just find the data for this question. And then I realized I can't just find the data for that question. And that's life. I mean, sometimes you have a great question, but it turns out there's no data. And you just have to wait. Maybe there will be data in the future, maybe there won't be. So this paper is a good example of a situation where in the past, sort of proxies were being used. Now we have a much more precise estimate, and we have technology being leveraged in a way that allows us to answer a question better. And it's important to note, this isn't a paper that has hypotheses being tested. It's a measurement paper. It's a quantification exercise answering the descriptive question, how much? How many seconds does it take, to resolve an SLP admission hearing, for example? Turns out not very many. As we discussed yesterday, 6 minutes. I got the 6 minutes from this paper. So, great. So, any questions about any of these papers? Or any questions about the discussion about hypothesis testing? I know I went through things very quickly today, so I'm happy to back up and talk more about any of the subjects. Oh yeah.
So on the paper in dissents, she makes an interesting point about two judges' benches and the difference in seniority between the two benches. Now the thing is, there's a constitution, there's almost a court convention where the senior most judge will sit. Okay, so the judges sit in whenever the division benches are made, the chief justice sits. The ordering is such: the chief justice, the senior most judge after them, and then we go back, and those are the presiding judges. Once the presiding judges are over, let's say by courtroom 15, then we start again from the chief justice's court. So the next senior judge goes there. And this is by convention. Okay. And so the idea is, whenever you go to the Supreme Court and when you argue before the Supreme Court, it is the presiding judge who essentially, it's almost like a training period for the junior judges to get to the stage where they eventually become presiding judge. So it's almost as if, and I don't know why this hasn't been mentioned, perhaps this knowledge was not available to her, but it's almost as if the presiding judge decides the matter on the spot, dictates the order to the stenographer on the spot. So there's very little time for somebody to jump in and say, okay, fine, I don't agree with you or disagree with you. The proceedings are, as you said, happen very fast, and the preceding judge has enormous power. One, because of seniority, and one, because he is the person the advocates are addressing. He is the person usually talking in court. Very few times in some specific assertive judges, the junior judge will actually speak up. Otherwise, it's almost universally it's the senior judge who speaks up. So that's perhaps something which hasn't been taken into consideration. In a constitutional bench, where the matter is much more important, there the field is much more open, and there it's not. This constitutional convention does not apply. It's the chief justice who set up the bench as he or she wishes. So maybe the convention and the fact that the matter takes so less is perhaps a good explanation of why two judge dissents are very, very, very rare.
Yeah, so I mean, there's a lot of reasons, and I think ideally what you want to do, and I think the paper does some of this, but certainly could have done more. And I mean, honestly, there's more than one paper to be written on the subject. I mean, there's so many. I mean, I look at this paper, and there's a half a dozen hypotheses being tested. Certainly the results with respect to any one of those hypotheses are what we might call suggestive. They're merely suggestive, right? In the sense that they certainly don't conclusively prove anything. But they are a pretty good start, and you could imagine a whole series of papers, maybe by the same author, maybe by other authors, trying to find other ways at building up evidence in support of or against these various hypotheses. And I think we'll talk more about this later in the week, but it's something that bears emphasis now. Is and we mentioned this yesterday too. You ideally, in order to establish the validity of some claim, you want it to make sense at a theoretical level, you want it to make sense in the qualitative data, and you want it to make sense in the quantitative data, right? So what you're giving us here is a set of sort of theoretical reasons based on experience, anecdote and experience, qualitative data, on what we would expect the court to do in these situations. And ideally, you want to test those sets of expectations right against the data. If we really do think that, if our theory is there's a set of seniority norms that apply in two-judge benches but not in constitutional benches, then we want to look for evidence, right, that's either consistent with it or inconsistent with it, right? The tricky thing becomes when you have a situation that's, you might call it overdetermined, right? You have a pair of data points, really low dissent rates in two-judge benches, really high, relatively high dissent rates in constitutional benches. But you have more than one theory that all generate the same prediction, right? And so when you have multiple theories that all generate the same prediction, like, is it the seniority norm? Is it the importance of the case? Is it just the sheer number of people sitting together that causes these effects? Then it becomes impossible to distinguish these theories in the data unless you can identify other predictions that the theories make that are different from each other, right? So the way that you distinguish theories ultimately is not by saying, oh, look, my theory is consistent with this piece of data. Well, so what? If your theory is also consistent with the same piece of data, that doesn't mean I win, right? It's still indeterminate. On the other hand, if there's another prediction that your theory makes that my theory doesn't make, Okay, now we can look at the data and see which one of these two theories does better on that prediction. So I think this is a challenge, for this question of why are descent rates so low, especially in two-judge benches. We have more than one theory, and maybe they're all true. Maybe some are true and some are false, but we need more. We need more fine-grained predictions that can be tested in the data than just, it'll be lower in a two-judge bench and higher in a constitution bench, right? Because all of the theories are consistent with that. And so that's a challenge for both for the theoretician, who says, look, if my theory really is about seniority norms and not about the mere size of the bench, I have to generate more specific predictions that can be tested in the data, right? And if you're the empiricist, you have to say, okay, I need to study these theories and pull out of the theories the predictions that can be tested.
So what exactly is the difference between prediction and hypothesis?
Well, in this context, where we're talking about empirical work and you're attempting to reject or fail to reject a hypothesis, the answer is there isn't really a difference. We talk about predictions in the context of some theory, right? Some theory about the way the world works, not a normative theory, a positive theory. This is a theory about what causes what, how the court system changes, or how the law changes, or whatever it is. We have some positive theory about what causes judges to dissent.
Is it that in hypothesis we need to find a causation and in prediction we need not?
No, a hypothesis could be a hypothesis merely about prediction, right? It could be a hypothesis merely about correlation.
Like you say, in every hypothesis you need to identify what is predictive about it. Every hypothesis has some sort of predictive element. Like for instance, if I say for example, if I say with the increase in number of judges, the disposal rate will also increase. So what is being predicted? The disposal rate will go high. This is the predictive value. So on the verification side, when you verify it with the help of a data set, this prediction may go other way around. This may go any way. So then you will check the nature of prediction which is happening. Prediction will definitely happen, but it may not happen the way you have placed it in the hypothesis. Like if it is a positive relationship, X in Y. So if I say that there is no change, even with the increase in the number of judges. So you are actually testing the predictive aspect of the hypothesis. Because every hypothesis is predictive. But whether that prediction is correct in the light of the data is something that you are trying to check.
I mean, I myself personally will use prediction and hypothesis interchangeably when I talk about my own work. But some people are more strict about their use.
Yeah. Any submission? This is a very interesting discussion. I think you should. I think we are discussing.
One question I wanted to ask from my friend that side, with your kind permission, sir. He told that if there are 2 or 3 judges in the Supreme Court of India, and for that purpose, that is even in the high courts, only the senior judge is addressed by the advocates and he asks the question and he dictates judgment most of the times. But this is not with the Constitution bench, he told. But what I personally perceive that in the Constitution bench, usually the senior judges are there. They are picked up from top 15, not last 5. So have you noticed this also? In Constitution bench, we in our country, only senior judges are there. We have 31 judges in the Supreme Court of India, including Chief Justice of India. And any important matter, especially with the interpretation of the Constitution, at least 5 judges are required to be there in the bench. And whenever the Chief Justice constitutes the bench for constitutional hearing, I think he picks up only senior judges. Am I correct or not? I do not know.
No, it's not necessarily the case. So, for example, the right to privacy judgment. You see, Justice Chandrachud is there, Justice Nariman is there. Both of them are not in the top 15.
Justice Chandrachud is not in top 15.
Not right now.
In terms of seniority.
And not at the time of the privacy judgment. And Justice, who was the Delhi judge who went?
I think he is.
Justice
He's
Paul
third
has
Chief
been-
Justice of
Paul
India
has
now.
been elevated just then.
Justice Chandrachud is just third Chief Justice of India now, if I'm not wrong.
No, sir.
No, so he's in 2022.
22.
22.
22, I think. 22 or 23.
So I'm sorry to interrupt, but I think the takeaway from this discussion is there are many claims that can be made about court practices based on individual observations that can be verified or not, right, based on empirical data. So if the claim is the Chief Justice selects membership to the Constitution benches either exclusively or predominantly out of the 15 most senior justices, that's a prediction. That's a hypothesis that is easy to test in the data. You simply go and look at the composition of the Constitution benches, and you can very precisely calculate the answers to these claims. And I guess what I would say is, one of the things that I think empiricists can do that adds a lot of value, that doesn't require a lot of creativity on the part of the researcher, but just requires attentiveness, is to identify situations where you see judges or lawyers or law professors saying, oh, well, of course it's the case that, or, well, we all know that this is true. And every time you hear that, ask yourself, well, wait a minute. Do we know this, or do we just assume this is true? Because there's a lot of things that are assumed to be true by lawyers that have never actually been checked to be true. So, for example, you see people say, oh, 95% of all cases settle in the United States. I tell my students in procedure every year, that's not true. It's the number 70%. People just don't check. Claims about the rate at which defendants file motions to dismiss claims brought by civil plaintiffs in the United States. There's this whole debate about motions to dismiss over the last 10 years in the United States. They're saying, oh, more motions to dismiss are being granted. It's a catastrophe. Nobody gets to go to trial in the United States. Well, if you actually look at the numbers, it turns out a motion to dismiss isn't even filed in 94% of cases. Not granted, not even filed in 94% of cases. So how big a problem can it be that motions to dismiss are being granted a lot of the time, when the only time a motion to dismiss is even filed is 6% of the time, right? So these are situations where you have raging debates among hundreds of law professors when the basic facts about the situation haven't even been checked. And so, part of my career has simply been going and getting the facts and being like, hey everybody, maybe we should reassess how we think about these problems and the facts. That's a huge contribution that empiricists can make that doesn't even require sophisticated statistical analysis. Sometimes doesn't even require hypothesis testing. I'm just saying, look, it's 94%. I'm not testing the hypothesis. I'm just telling you what the numbers are, right? So that's this is a good example of the kinds of ways that empiricists can help inform debates that otherwise, aren't specifically about empirical questions at all. Okay, well, I guess this is about the end of our time anyway. So
last week.
Oh, I'm sorry. One more question.
Professor, while writing the paper, what is the best method? Like you have given 3 readings, and one of the paper, like Professor Vajpayee's paper, we had the hypothesis in the starting. So your hypothesis, you write in the starting, then you try that hypothesis is right or not, or you test one hypothesis, then take another. So according to you, what is the best way? Because what example that has been told by Professor Vajpayeee in Delhi University. So the researcher might, while writing a dissertation, might have forgot that what was the real hypothesis that they have taken in the beginning.
So I generally prefer putting the hypotheses together at the beginning, so they're all in one place. I do like that style. But the challenge always is you want to organize the paper in a way that is as that clearly frames the motivation, the reason for the paper in the first place, explains that, lays out how you're going to test it, lays out the data that you're going to test it with, tests it, and then explains the results, right? And so usually the best way to do that is, once you've explained why you're asking the questions you're asking, then say, well, these are the specific, this is how I translate my research question into specific hypotheses, right? Now, it could be the case that, if you have a lot of hypotheses, sometimes it's hard to keep track of them, right? And so you might end up repeating them later on, one at a time, as you test them. So that, so there are different approaches you can take to that, and I will spend some more time later in the week talking about sort of, these are the pieces I think every good empirical paper should have. So we'll talk a little bit more about that too. So, good question.
One just kind of footnote to this observation. Generally what happens in paper, you are not supposed to have too many hypotheses because the size of the paper may not allow you to have too many. But if you are writing a research report, there definitely there could be a possibilities to have too many hypotheses. To my mind, the best way to classify them or to place them into different chapters. So suppose I have 4 chapters. So suppose my hypothesis is more suitable for the discussion in 2nd chapter or 3rd chapter. So there I'll, again, actually we have to address, paper is written for the audience. It is not for written our own intellectual consumption. So there should be a reader angle. If you have a reader angle, then you will be able to write. So in your chapter itself, you will start discussion and you would attract the attention of the audience or the readers that we had posed a relevant hypothesis relevant to this discussion, and this was the hypothesis would be restated. And then you would bring the data in order to verify that hypothesis, and then the discussion will take place around that hypothesis. And then you go on, examine, and then you can again, in the end, you can wrap up with final. And in the end, all hypotheses can be summarized. If you are testing a theory with the help of too many hypotheses, then you will address that theory. Then ultimately, as he was saying, that your hypothesis must address to that theoretical contribution or verification of a particular theory. Because popular theories are generally held without any empirical evidence. But is there any way or is there any manner your hypotheses are contributing or addressing or contradicting the prevalent notions? Because I remember in India, every unique incident happened. Very seasoned Chief Justice in front of all dignitaries said that please increase the number of judges because it is telling upon the quality of justice, and he got emotional. So a piece of research I have seen after some time contradicting the popular notion or a popular theory that increase the number of judges and there would be a greater disposal, which is not correct. It was shown in a team of researchers who had done, and they have shown that essentially the disposal rate will not increase with the number of judges increasing in the court. Now, so popular, this I don't know correct or incorrect, but this finding is against the contrary to the popular theory. Popular theories increase the number and there would be increase in the output. But if you look at the case of Kerala, the state of Kerala, in the state of Kerala, the judges, the rate of disposal is very high despite having a lower ratio of judges to the cases as compared to UP or Uttarakhand and Kolkata and other places. So a new theory is coming up that the number of judges is irrelevant as far as disposal rate is concerned. I don't know, but that was done. So it defeats the entire contention of the Chief Justice in front of the Prime Minister. And this is a wonderful paper. That because in India the pendency is contributed every year. So you have, if you see the per annum cases, that in docket cases, is quite possible to deal with the existing number. It is the pendency that you have kept up for all these years, which is the problem. So sometimes we also go by the popular beliefs without really verifying the. So we have a lot of popular notions among ourselves. Yes.
Sir, I have one question. That is, when we write a good theory, so generally the idea is a good theory will point to some doctrinal component,
Yes.
right? But is it actually a belief that is popularly held, or can it be also a doctrinal component? Like your paper on witness protection and issues, right, related to that. So what will you identify as that good theory?
Yeah, so like suppose so there are two ways. If you are testing an existing theory is, suppose if I feel the witnesses are generally, they tend to turn hostile in heinous offences where powerful people are involved. So there are enough evidences or studies in India conducted, or it is popularly held that the cases involving high profile people, because we have a lot of cases, even in, all those cases, Jessica Long and all those, where the witnesses. So we have developed a hypothesis, a theory informally though, it's not a very rigid theory, that where the involvement of rich and high profile people is there, the witnesses have a tendency to turn hostile. So suppose a researcher wants to test this particular theory, then you have to collect the data around that kind of cases. So if you are able to bring some cases to be able to test whether this proposition is held or not, is it tenable or not. So it is actually examining an existing popular notion or a theory. That is one way. Or other way, if you want to theorize something very new, which is nowhere there. So suppose you have a hypothesis, I said that, like if I say that, which is something very contrary to belief, I have given the number of decisions. So this is a kind of new theorization. So are you going for a new theorization? Then you have to bring your data set accordingly. Then you have to create your own theorization. So sometimes what happens, I think, which is a very important thing since we are discussing now this, I have seen also a very peculiar kind of studies where I have found the researcher was able to create or collect some very interesting set of data. And the researcher has also interpreted data, these are my findings. And then the research stops there. Means you have only described the trends in your data, the frequencies in your data, the different combination and permutation in your data. But is it possible for you to take up these findings in order to create a theorization which is new to the existing knowledge, or are you in a position to contradict any existing theories with the help of this data? I have seen most of the time our researchers stop here. We don't go beyond telling that this was the finding of this study, this is the frequency, this is the data. But in longer terms, is it your data, is there any data, or your data set is really contributing? So can you connect your findings with any theoretical frameworks available in your field? Because I strongly feel that in every subject there is a theoretical framework available. So suppose I am writing in criminal law. So in criminal law there is already a lot of theoretical frameworks available in environmental law, corporate law. So is it in some way your data is contributing or contradicting any particular theorization in that particular field? That is something very important. And I think this workshop would strongly advocate you to look at the theories in your respective field. If you are doing an empirical research or any kind of research, what theoretical contribution, because when we talk about fundamental research, basic research can only happen when you really try to connect the data with the theory. In India, law as a discipline could not grow enough. The main reason has been not much research has been done to fit this connect or to fix this connect between the data and the theory. So sometimes we have enough data, but the data will not do anything unless you are able to really, examine that data in the context of theoretical frameworks. So a lot of theories are there, but are we really contributing? Sometimes we as academicians must take up a theory which we feel is important and examine that theory in your context in different ways.
So that means describing that theory or backing of the theory is also important part of the research design.
Yeah, I would not say backing, I would say please address that thing.
Yes.
If your data, so suppose, I think it should be done in the beginning. You would not be in a position to address the theory in the end if you had not planned it in the beginning. Because those researches are then designed very specifically. Because you suppose a theory I am looking at, it has 4 or 5 very important variables. Now when I collect the data, I have also to collect the data with respect to those variables which are the part of that theory which I am aiming at. Then only you would be in a position to apparently address that particular theorization. So if I say that in chronology, I know most of the theories in chronology basically. So if I say that lot of crime is situational in nature rather than it is the product of a pathology or something. So then I have to see if I am collecting the data, the extent to which the crimes are situational. Are they the product of bad pathology or bad socialization or other kinds of things, But in order to check this hypothesis, you have to consider the theory in advance and make it a part of your research design. Those researches are theory testing researches. Now theory testing research is a very important contribution. So like a lot of research you read in JELS, Theodore has mentioned a lot of research I remember. And one research he often, we have shared this diagram only, so I recall, I was sitting and we were discussing a very interesting theory. So he had a paper where he said, in India, because he has written a lot on India, he said civil litigation in India is declining. What does it mean? Now, what does it mean? So the first meaning is that the people are not having so many problems. Number 2, they are avoiding the courts. They are avoiding the courts because the civil litigation is too cumbersome. And a third theory, so he is testing whether civil litigation is a product of, civil litigation is an indicator of a pathological society. Because in many countries, in the European and even in the US, the civil litigation is rising. So does it mean those societies are moving towards a state of pathology? Or people are just becoming too aware? Because other day the Daksh study, Daksh is a very, they are doing good work. Daksh says in India only less than 25% people are invoking the courts for their issues. This is a startling finding. So less than 25% people are actually invoking the courts for remedies and for different regression. So we can check whether it is happening. Like for instance, I discussed the other day, because these are the important theories. Like in India, we don't know much about litigants. Who are the litigants? We have a lot of theories around litigants, like whether poor litigate more, whether the rich people litigate more, whether litigation in taxation is more, whether litigation in... These are all the part of our, general perceptions and notional understanding about some vital issues relating to Indian legal system. So there is a huge scope to check all these things with the help of empirical data. And I would say a lot of theorization can happen if we are able to, create some data set around all these issues.
So what was that theory? Whether civil litigation is an indicator of?
State of pathology. A pathological society. Social pathology is a very classical term which used to be, is no longer in use. But earlier criminology has been using. So Mark Galanter was also probably has written on this subject. Mark Galanter and Theodore Eisenberg, they had done a paper, a very good paper. And they have tested this entire notion and idea that what does it mean when civil litigation is declining or increasing. It's a very interesting issue. So if you do not have anything to say, then should say.
Yeah, I think we're out of time, so
Yes, yes.
this is great.
Wonderful. Great. Thank you so much.